Gordon.
May it please the court, I'm Joshua Gordon. I represent Jennifer and Martin Woodford, who are here in the courtroom this morning. I want to start with the construction defects, as my brother did. The standard of review, as you know, is deference to the fact finder on all the issues, and there's nothing in the Superior Court's order suggesting any unreason, illogic, or neglect. The court reviewed an enormous record, a 13-day trial, 89 exhibits, 1,500 pages.
Except here, the court seemed to fill in some of the gaps that were left by some of the, well, I'll use the word incomplete or not concluded structural analyses.
I don't think that's what happened. The court was, the Knight's expert conceded violations in every place, including the roof and the basement issues. She only disputed the extent of violations, the repair methodology and the cost, but conceded that there were violations everywhere. And the Woodfords, both their experts, could see those violations with their naked eye without any prompting by anybody, just by a trip up to the attic into the basement, that there were code violations that experts would understand are code violations just by looking at them.
Even though things were approved at the point of certificate of occupancy by the local building inspector.
The local building inspector is immune from suit, and the law is that the contractor is required to meet code. And the fact that the contractor builds to the building inspector should not be condoned by anybody, and that's not what the law is. So I don't think that's a defense to the Consumer Protection Act.
So what was the support for the trial court's conclusion that contractors in New Hampshire typically satisfy the building inspector as opposed to satisfying the code itself? Was there any testimony to that effect?
Yes, there is some testimony to that. And the Mr. Gill, I think, who was the framer, talked about that. I don't think he was an expert in any area, but he obviously was framing. And he said they do that. And also Knight talked about that. But if to the extent that's true, I hope buildings in New Hampshire don't fall down. I think the more important issue in the Consumer Protection Act is that the court focused on what's common in the industry. It's not reasonable to believe that a man who's been in the business for 30 years can mistake the guy at the lumberyard for an engineer. He's not an engineer, and I'm sure they are competent in what they do, but this was a custom home, from the ground up that needed engineering. And I understand Mr. Knight might not have wanted to incur the costs of expensive professionals, but he was building custom home and needed an engineer. And so the fact that this is the way it's done in the construction industry, that's great for probably, vast majority of buildings. But when it's not great, this is what happens. You get code violations. And the Consumer Protection Act is a Consumer Protection Act, not a business-to-business protection act. And in this case, the Woodfords were consumers, one-time consumers of building services, and they didn't know who at the lumberyard does what.
What distinguishes this from just a standard breach of contract claim? I mean, it is a custom house and engineers were involved, but it just seems pretty straightforward breach of contract, and that would take it outside of 358A.
It is a standard contract in the one sense. The problem here is that, or the Consumer Protection Act issue, is that Mr. Knight lied to the Woodfords repeatedly, and some of those lies seem sort of inconsequential. How many houses he built?
Where's the rascality?
He clearly lied, but
where's the rascality?
The rascality is the lying about an engineer.
How about charging your client $7,000 for final plans that were never produced?
Charging my clients for exactly. There's repeated lies that Mr. Knight told the Woodfords.
What statements are you relying on? What material misrepresentation?
I think the quotes are laid out in my brief, but
I only found one quote. Maybe I didn't.
No, I think there's 3 or 4 where he said, my engineer is looking at this. I'm going to go back and do this with my engineer. Don't talk to the architect that wasn't an architect. Several, 3-4 times, both before construction and during construction, Mr. Knight essentially told the Woodfords that there was an engineer involved.
Was material misrepresentation raised in your notice of appeal as a basis for the CPA claim?
Yes, I think so. I guess I think it was. I think we raised the...
As I read it, it's your notice of appeal was really talking about this, relying on the industry practice that was the basis for Judge Anderson's conclusion.
And that was the genesis of the material misrepresentation, that the industry practices were some assumption that there was an engineer back behind the software somewhere, but the misrepresentations to the Woodfords is what the court should have focused on, and not what is industry practice. That's the industry's business that Woodfords take no position on.
Is rascality something that we determine de novo, or do we give deference to the trial court?
It's deference to the trial court on rascality, but I think the issue of construction of the Consumer Protection Act is an issue of law, and where the focus is in the Consumer Protection Act, whether it's between two businesses over here or the business to the consumer, that's an issue of law that that this court looks at de novo. I think the Hughes opinion says that, and I think Sedaris and Morin, the siding contractor and the roofing contract, also suggest that.
Rascality is an objective standard.
Yes, yes.
Is there any other evidence besides the other lot being cleared and the representation that your clients could cut to the stone wall, both of which I understand happened before this restriction document was agreed to, the covenants? So was there any other evidence to support the waiver?
Yes.
Found by the trial court?
The Woodfords and Mr. Knight met at the site at some point, maybe more than once, and had conversations. And it was...
Was that before or after the covenants were accepted?
The covenants were accepted at the time of contract. And so this would have been sometime after that. And the parties had a conversation, and the court heard testimony about it and determined that, he said kind of thing, and determined that that there was a waiver, that Mr. Knight encouraged the Woodfords to cut back to the wall. And it's not based just on this 2010 video. That's just corroborating that Mr. Knight himself cut back to the wall, but he encouraged them to cut back to the wall. And the Woodfords had told Mr. Knight that they had teenagers who played outdoor sports, and they needed a big backyard. They told him they might want to put a swimming pool in some point. So cutting back to the trees, making a big backyard was discussed, and that's what the court found. If there's no more questions, I'll take my seat.
Thank you, Attorney
Thank
Gordon.
you.